You might think I'm crazy, and you wouldn't be wrong. Hello, my fam. It is Perez, the queen of all media, the original influencer, journalist, podcaster, and your number one source for everything It Ends With Us saga. If you did not catch the exciting and nerve-wracking development from earlier, I got a court date. I am in my Elle Woods era, and I am going to show up literally, truly wearing my florals in the federal courthouse in Las Vegas next Thursday. And if you're a member of the media, I would love you there. Please cover this. I think it's important for not just the It Ends With Us saga, but also society. I'm talking about some real serious issues here. Protecting journalists and free speech, abusing discovery, and really rich, famous people using their money to threaten, harass, and intimidate. That's especially relevant now, given everything that Donald Trump has been doing in 2025 with his lawsuits against people that don't do things he likes, and 2024. And just even threatening to sue people, and law firms and big media companies just cowering to him. In her own way, blessedly unaware Blake Lively has been doing the same. The zero-time Oscar-nominated actress is using her husband's money to help her feel better about herself. She's going after people like me who hurt her feelings. She's hyper-focused on this alleged smear campaign and getting proof that seemingly does not exist, and is not expending any energy, it seems like, on proving her alleged sexual harassment that she suffered, not just from Justin Baldoni, but also from Jamie Heath, his producing partner. So I filed my motion to quash her subpoena that she served me with here in Las Vegas. The date is set for next Thursday for a hearing on this. It's in federal court, it's open to the public, and it is going to be Thursday, August 28th at 12:15 p.m. at the federal courthouse in LV Courtroom 7C before Judge Richard F. Boulware II. This judge is a person of color. I've got to find a way to reference that Blackface Betty literally admitted to doing blackface. There's video. You can watch it. Just Google it. But more importantly, I just have to answer honestly and state my many valid reasons for why she is seeking my privileged and protected information as a journalist. And I think that the imagined victim really underestimated me, because Elle Woods ended up winning. Wouldn't it be amazing if I come out on top, me, by myself, not with a lawyer, representing my interests pro se, if I'm the one victorious? That would be quite the story. I did not give her what she wanted. I have fought this. It is the right thing to do for me, for fellow journalists, for free speech. And I really believe that. And I truly believe the law is on my side. And as I told you previously, Lady Antebellum was trying to outmaneuver me and trick me through her expensive and mid lawyers into playing in her court. Her court being the Southern District of New York, where I believe, it is my opinion, the judge there, Judge Lyman, is biased, in her pocket, not handling this well. More than that, I think, it is my opinion, he's corrupt and has conflicts of interest and has consistently shown his bias in her favor, and I don't think I could get a fair shot in that court, which is why she's trying everything in her power to get me there. Ku Klux Khalisi's lawyers argued that because I filed a defensive motion for protective order to hopefully stop her abusive, in my opinion, discovery practices, that me taking that defensive measure, I immediately subjected myself to the jurisdiction of her lapdog, Lyman. No, 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 no. However, because this judge can, because he is biased, I think, he issued an order that if I did not reply to her argument and her cross motion to compel me in his court, that he would rule without opposition. Even though legally, that's not how it works. The subpoena that she served me with listed Las Vegas as the place of compliance. Any issues around that subpoena need to be litigated, figured out here in Las Vegas, where I live, where I work, where I was served, and where her subpoena lists as the place for compliance. Lying Lyman said in his order that he would rule without opposition if I didn't respond, and if he determined that he had jurisdiction over me. If being the operative word. So some of you might know I did everything possible. I asked the judge for a delay in his ruling until he determined if he had jurisdiction over me. He said no. I then asked her bestie to pause until everything played itself out here in Las Vegas, and he said no. He ruled, the motion for an extension is denied. Lavandera seeks in effect a stay related to Lively's motion until the district court in Nevada issues a ruling. But Lavandera has not demonstrated good cause for briefing on Lively's motion not to go forward. Lavandera is free to argue in his opposition to the motion to compel that the court should defer ruling until the district court in Nevada has ruled. Then this next part was so slimy. That's why he's Slimy Lyman. He wrote, it appears, however, that Lavandera has not yet properly served his motion to quash in the District of Nevada. And the court, meaning his, does not assume, nor should Lavandera, that it will necessarily defer ruling in favor of a proceeding that is now further behind than the one in this court. The word assume is very important there. I'm not assuming anything, Judge. I know. He said, to the extent Lavandera has already argued in his motion to quash that the subpoena is improper, he is free to repeat those arguments in his briefing here. That mofo, actually, I've not shared this with you all before. This is the first time I'm verbalizing this more than thought, this belief. Lyman already knows how things work. He's a judge. He also knows already that he does not have jurisdiction over me yet. He could eventually have jurisdiction over this subpoena if the judge in Las Vegas transfers it to him. And yes, she filed a motion to transfer this week in Nevada. The mint julep mistress responded to my motion to quash this week here in Las Vegas and included a motion to compel and also a request to transfer. The motion to compel was if the judge here did not grant her motion to transfer. So listen, it is possible I'll end up with Judge Lyman, but I think it's unlikely. The shampoo company owner has to prove exceptional circumstances for the transfer to be granted. And in her filing this week, she did not prove any exceptional circumstances. It was a very basic disagreement about the terms of the subpoena and the subpoena itself. It's unenforceable. Everything she's asking of me is privileged and protected by the law. Reporter's privilege, the Nevada Shield law. And Lyman knows this. He knows I'm a journalist. He knows the jurisdiction is here in Las Vegas. I already told him the judge here in Las Vegas ordered that the place of compliance is Las Vegas. And Lyman told me, well, if you don't respond, I'll rule without opposition. He just wanted to waste my time. That's what I have not said before. He wanted to make me suffer because I wrote some spicy letters to him because he could. It was well within his rights as a judge to say, well, you got to do this. Oh, and be careful because if you don't, that could backfire. He wanted me to waste a lot of time and energy and cause me turmoil, strife, severe stress and anxiety as payback. Judges are supposed to be better and do better than that, even when a movant like myself is a clown. But you know what? Forcing my hand to respond just goes to show the perception of bias that Lyman has. And that is very powerful. Even the perception of bias, I think, will help me in making sure that this subpoena drama is not transferred to the Southern District of New York. And I'm nervous, but I'm looking forward to this hearing for next week. And I just wrote a letter to her lapdog, letting him know all about it. Let's read it. Dated today, the subject, update out of the United States District Court for the District of Nevada. Esteemed Judge Lyman, I, Mario Armando Lavandeira Jr., known professionally as P to the E to the R to the E to the Z to the H to the I to the L to the T to the O to the N, write as a non-party in Lively versus Wayfarer Studios to inform the court of activity out of the United States District Court for the District of Nevada that Your Honor should be aware of. As I previously informed this court, in July, I filed a motion to quash the subpoena served on me by Miss Blake Lively's counsel. That motion was filed in the United States District Court for the District of Nevada. See Exhibit A. The case has been given the following name, in regards Mario Lavandeira Jr. And the case number is, then I write that. My motion to quash has been properly served on Miss Lively's counsel. See Exhibit B. The subpoena at issue lists Las Vegas as the place of compliance. I maintain that Las Vegas is the correct and only forum to litigate issues regarding this subpoena, such as to compel, quash, or transfer. Earlier this week, Ms. Lively submitted in the United States District Court for the District of Nevada in opposition to my motion to quash, and she also entered a cross motion to compel. See Exhibit C. I have already responded to Ms. Lively's filing. See Exhibit D. And today, the Most Honorable Judge Richard F. Boulware II issued an order setting a date for next week to hold a hearing on this matter. Judge Boulware wrote, Before the court for consideration are the motion to quash by In re Mario Lavandera Jr. and the motion to seal document by In re Mario Lavandera Jr. A motion hearing is set for August 28, 2025 at 12:15 p.m. in LV Courtroom 7C before Judge Richard F. Boulware II. Then I tell Lyman, Slimy Lewis, I am confident Your Honor will want to wait in ruling on Miss Lively's motion to compel in your court. Now that you've been informed, her counsel has been properly served, they have responded, and a hearing date has been promptly set. This matter should be resolved expeditiously in Nevada, where it belongs. If my motion to quash is granted in full by Judge Boulware, then Miss Lively's motion to compel in your court would be moot. I expect that to be the outcome. Respectfully submitted, Mario Lavandera Jr. I am loving all of this, and I'm also hating it. I want to be done. I'm ready to tap out. There's no need for this to go on much longer. I am happy to just be a commentator, a reporter, an observer, a non-party that's not having to respond in the court docket. So I am feeling very confident. I truly believe the law is on my side, and even though I want and need to protect my sources, I have told the judge in Las Vegas in my response, I'm willing to sign an affidavit, a declaration, multiple ones. I'm willing to be deposed. I'm willing to testify. I am being cooperative, but I'm also understanding the law and the ramifications of what is being asked of me. What this judge in Las Vegas is going to decide is not just pertaining to me, but this affects all journalists, reporters across the country. So I hope to see at least the Las Vegas Review-Journal in that courtroom and everybody else. Fly in. Enjoy Labor Day weekend in Vegas afterwards and get a show from me and my florals in a courtroom. Crazy. At the beginning of this year, if you would have told me that things would be how they are right now, I would have never believed it. Wild. So yes, I did poke the bear, but I did it with confidence. I know why Lyman did what he did, and he's not going to rule before this other judge in Las Vegas. He won't. Because even though he's got hurt feelings too, he knows that's just beyond unacceptable if he were to rule before the judge in Nevada. Period. And just to also state this, one of the many reasons I sent this letter to the judge today was also to make sure he knew this hearing was scheduled next week in Las Vegas, because he somehow knew I didn't properly serve her lawyers. Wonder how he knew that. Wonder how he was monitoring my case last week, but I wasn't sure if he was still monitoring it. So I wanted to make sure he was informed. I'm just keeping the judge up to date. And maybe a slight poke too. Or am I completely a fool? Did I really misfire? What do you all think? Let's discuss it all in the comments section